Well, welcome back for the third video of the night. At the very end, I'll talk to you about the questions regarding for this particular unit. Um, but I just want to say that when you're dealing with instruction, state law, chapter 115C is where you find anything in education. So any kind of questions about instruction could be found in 115C. You have your own our own state board policies, or if you're in another state, their state board policies, and then of course your local policies that are found in your own school board policies. So the chapter talks about several different topics here. The first one it talks about is censorship, and the biggest case of censorship. There's two big cases of censorship. One ruled against the district, and another ruled in favor of it. BOE versus PICO dealt with a school board's removal of books from libraries, junior high, senior high books that had previously been approved by a committee, appointed committee for the sole purpose of reviewing books. They didn't like the decision, they removed the books. Well, the Supreme Court said that you can't do this. You've enacted practices and policies to remove books, and they followed those practices. And so that was overruled. And so you'll see nowadays, you'll see school districts that have some type of a practice or policy that addresses this at a school level. One superintendent in Charlotte Mecklenburg, that's several years back, removed a book, and it caused a lot of controversy. And anytime you remove books, it causes controversy. The other case is Hazelwood versus School District versus Kohlmeyer. And this is a case where actually the district could censor. It was a newspaper, school newspaper, and information was written about this particular student, that the principal censored that information, and the school district was found ruled in their favor. Second area is academic freedom. As you know, we have lesser amount of academic freedom in the public schools, because we're dealing generally with a state curriculum. Now it's called the Common Core. On the side note, I met our local representative, who is the head of the education committee, who basically said that the Common Core, there's been a lot of controversy in that, but the Common Core, the standards from the Common Core, let's put it that way, will be the minimum standards moving forward as they make some decisions this summer. But even the state, or even the universities have less academic freedom than they once did. For example, the evidences that you complete here all are impacted from the state level. Every university that has a executive leadership program has to do something similar. You have to basically have some way of documenting that the student has passed certain competencies, and so Gardner-Webb's done that through your evidences. Copyright compliance, I think that's pretty evident as to what that means, as far as not copying someone's, you have to give credit, or you have to pay a fee regarding anything that's not your knowledge base, that you didn't write it. If somebody else did, you've got to give them credit for it or pay for it. Student intellectual material. The next one is student proficiency testing. Deborah P. versus Turlington is a case several years ago that basically involved a competency test that was made a mandate for graduation, and the student was made note of this about 13 months prior to graduation. She won the case. Basically, it said 13 months is not enough time, and therefore you'll see today, whenever there's a change in the graduation requirements, you'll see that generally will start in the 9th grade class, moving forward, not escalating to the sophomore or junior class for this, and that's why that is. And then last thing is instructional privacy, and it's FERPA, and I think everybody is aware of the FERPA laws, Family Educational Rights and Privacy Act, 1974. Certain information that can't be violated, information that can't be, it's confidential information. Student grades are generally one of those. There was a case, though, it came out 6 years ago, something like that, regarding students grading other students' work that was found to be constitutional and not a violation of the FERPA. And so there's not a lot with regards to instruction anywhere in the law, but it's mostly in policies, and there are there's be state specific with regards to laws that you'd have that, and not federal laws. And so I clarify that statement here. So the last thing I need you to do, it'd be the last point as far as a question for your email for me, is to cite for me at least one school board policy that's in your school board that deals with instruction. In our school board policy in Union County, it is, I think it's chapter 5 of the policy handbook, and so you just have to find the chapter in your policy handbooks that deal with it. So that's one thing. So just find one policy, and maybe a little summary of what that policy is. It doesn't have to give me a lot of information, just kind of a little brief summary, 1 sentence, 2 sentences type of thing. And then provide me either with a state law that deals specifically with, and you need to cite it, state law, and those come from 115C, chapter 115C of the North Carolina state law, or your state board policies in North Carolina. You can go to the North Carolina State Board and pull up their policies and just provide me one. So either one of the state law or state board policy, and then one local policy deals with instruction. So that's the third question here. Just to remind you of the other 2 questions in the legal framework. I had the question as to what appellate court, federal appellate court, are we in? And the second one was under church state, was to provide me an example at your school, or it can be a district, where you've seen something that you've questioned as to whether that's in violation of the church state laws that are out there. And that concludes our videos for tonight, and I'll be back on Wednesday. Have a good night.